2, and 3. Those are names that aren't found in any reciprocal discovery provided by defense counsel or any discovery that had been previously served by the state.
Okay, who are witnesses 1, 2, and 3?
Witness number 1 is Miss Kamisha Griffin. Witness number 2 is Miss Cassandra Salloway. And then witness number 3 is Mr. Todd Crosby from Fall Line Forensics, LLC.
An expert witness?
That's the state's assumption. I know, Your Honor, obviously there's the statute for discovery, 1716-4, as it relates to witnesses to be served, the timeliness for witnesses to be served by defense counsel, especially as it relates to expert witnesses and expert reports and things of that nature found in that code section. In addition, Your Honor, on May 8th of this year, Your Honor filed an order specially setting this case for trial, outlining the specifics and the requirements from each party as it relates to turning over expert witnesses and any additional motions, minus any motions in limine, which can be made at any time, either in writing or orally. So as it relates to those 3 witnesses, especially witness number 3 listed, it's not only in violation of the discovery statute, but also the court order that was filed on the 8th day of May of 2025.
So for those 3 witnesses, 1 through 3, you've never received any notice?
Correct.
Okay.
State's asking for them to be excluded.
Okay.
Well, a couple of things very briefly, Your Honor. As far as witness number 1, is that Mr. Crosby?
Griffin?
Number 3, I'm sorry.
Oh.
Crosby. He is a witness that testified at a previous hearing, and the state is fully aware of him. They have his information, his resume. They know all about him, and they've known about him for quite some time now. So there is no issue in terms of surprise. That cannot legitimately be argued when they've talked to him and they've seen him testify in this very matter before. As to witnesses 1 and 2, a couple things. I guess on Monday when we started, I think that was Monday, the question I asked the court was that we recently learned that the state re-indicted this case in August of this year, and I believe that was filed on September 5th of this year. So I asked, are we proceeding under the old case or the new case? And the state indicated that we are proceeding under the new case. So based on that case having been re-indicted within the last 2 weeks thereabout, the notice of those 2 witnesses is timely. It is 5 days prior to when we'd be calling them as witnesses. And if the state would like, we'd love for them to have the opportunity to speak with them prior, and we would accommodate them. But we are here to prove this man's innocence, and we have witnesses who can do that. So the remedy would not be to exclude anybody. The remedy would be to accommodate their communication, and we'll do that as well. So we ask that none of the 3 be excluded, Your Honor.
Okay, I'm going to take it under advisement, but in the meantime, make those witnesses available to the state if they wish to interview them. And is that correct? Do you want to respond?
I mean,
In terms of the expert witness?
in terms of the expert witness, I don't know of any hearing in which he testified in. If that happened, none of the 3 of us were present at that time during the testimony of that.
Okay, that's what I wanted to look up. So before I rule, I'll look at all that. When do you think he testified?
He testified in the hearing, Mr. Abatte was present, and that was before Judge Schwal. And it dealt with the state having gotten rid of the piece of evidence that could have conclusively been exculpating. They got rid of the car. We had a hearing about them having gotten rid of the car, and that was before Judge Schwal, and that expert testified as to trajectory.
Okay, well, we'll go looking for transcripts and see what we can find out. This is the difficulty of my being the 3rd judge in the case. I just don't know.
And I was present on that day during part of that hearing, so that's not untrue that I was there, but if this witness testified, I was not present during that time.
Okay, I'll see what I can find.
All right, thank you, Your Honor.
Okay. Do we have an update on the test? We're good? Okay. All right, anything else we need to take up before the jury comes out? Okay. All right, so we're ready for the jury.
And we would like to invoke the rule, Your Honor.
Okay, if there's any witnesses present, it's time to step out. Be sure not to discuss your testimony with anyone of the lawyers who are going to be questioning you. Do we have any witnesses in the courtroom as far as the state knows?
The only witnesses is the,
Okay.
the mother who will be testifying, but.
There's an exception for her.
But
That's
may we
correct.
approach briefly? Your Honor?
Yes, come on up. Council, the live stream is starting now, so if your microphones are on, you may be picked up. So just a heads up on that. Did you guys catch that at the state's table?
Yes, Your Honor.
Okay, just make sure your microphones are off unless you want to. Just a general announcement for the courtroom. The media has filed Rule 22 so that they can record. No one else is authorized to make any recordings in court. So if the deputies see you with a phone out, they're going to approach you about that.
Your Honor, does the court have a position on witnesses being televised or brought or recorded, I should ask?
I mean, typically the witnesses are recorded unless they're underage. I'm going to let the jury know that they won't be recorded. Did you have a request to make about that?
Yeah, we have a witness who has indicated that she would not like to have cameras on her, if
Okay.
at all possible.
During your case?
Yes.
Okay, well, we could, just remind me, and we can take it up with the cameraman and the media and see if they're agreeable to that.
All right, thank you.
Okay, thank you. My experience is they typically cooperate.
All rise for the jury. All jurors are accounted for.
Good morning and welcome, members of the jury. Just as I notified you previously, during jury selection, there is a camera here, but at no point will you be recorded. Okay, everybody comfortable with that? All right. In addition to that, this case is being live streamed. What you'll see is whatever's on the Zoom, you are not included in the live stream. So there are cameras on the participants in court so that people can see the evidence, and if people are interested, they're watching on a live stream, but you will not be shown on the live stream either. So neither the media nor court staff will show you. If you have any questions or concerns, just let me know. Okay. Okay, so let's start with some housekeeping. In advance, I'm sorry my computer doesn't go down lower, so I will rarely be seeing some of you. Please don't enter the courtroom again after this point unless the deputy brings you in. Please wear your juror stickers. I'm going to remind you that no one but staff may speak to you. This young lady to my right is Mahar, and she's going to be assisting during the trial as well. She's another person besides the staff I already introduced you to that you can approach. Okay, she's a student intern. If the lawyers don't speak to you in the hall, don't be offended by that. They're just not allowed to. They can greet you, and that's all. So if you have any issues, speak to a deputy or someone on my staff. Typically, we're going to start at 9:30 and we'll quit at 5. If we think that we need to have a long day, we're not going to do that without getting your permission first, because I know some of you have childcare issues. So typically, you can count on business hours or a little earlier than 5 o'clock. Okay, before we go any further, I need to give you your trial juror oath. Will you all stand and raise your right hands? Do you solemnly swear or affirm that you shall well and truly try the issue formed upon this bill of indictment between the state of Georgia and Julian Conley, who is charged with murder, 2 counts of felony murder, 5 counts of aggravated assault, criminal damage to property, 2 counts of possession of a firearm during the commission of a felony, and 8 counts of violation of Street Gang Terrorism and Prevention Act, and a true verdict to give according to the evidence, so help you God? Please say yes if you accept this oath.
Yes.
Thank you. You can be seated. As I warned you previously, there are going to be times that I'm reading you jury instructions. If you are a person who has benefited by taking notes, you can, but just understand at the end of trial, after all of the evidence and after all of the arguments, you're going to receive a written jury charge. So don't feel that you need to transcribe the instructions that I give you. Okay? Ladies and gentlemen, you've been sworn and impaneled, and you are about to try a criminal case entitled The State of Georgia versus Julian Conley. The prosecutor read the indictment during jury selection, and you will have it during deliberations. The defendant has pled not guilty to this indictment, and he denies every charge in it. This indictment and the defendant's plea of not guilty present the issue that you have been selected and sworn to decide. The indictment is the way that the defendant is charged with committing crimes that violate the laws of Georgia. The charges in the indictment and the plea of not guilty are not evidence of guilt, and you may not conclude that the defendant is guilty based upon the charges or the not guilty plea. The defendant is presumed to be innocent until he is proven guilty. The defendant begins the trial with a presumption of innocence in his favor, and this presumption stays with him until it is overcome by the state with evidence that convinces you, beyond a reasonable doubt, that the defendant is guilty of the crimes charged. You may not convict the defendant of any crime unless each element of the crime is proved beyond a reasonable doubt. The burden of proof is on the state to prove every essential element of the crimes charged in the indictment beyond a reasonable doubt. The defendant has no burden of proof at all, and the burden never shifts to the defendant to prove his innocence. However, the state is not required to prove the guilt of the defendant beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. It is the doubt of a fair-minded, impartial juror who is honestly seeking the truth. It is the doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but it is a doubt for which you can give a reason based on consideration of the evidence or a lack of evidence, a conflict in the evidence, or any combination of these. My role is to determine the law that applies to this case. I will instruct you on the law that you must apply to the facts in reaching a verdict. I'm giving you some of these instructions now. I will give you more detailed instructions at the end of the trial. You must decide the facts of this case from the evidence presented and then apply the law that I give you to those facts. Evidence is how a fact is proved or disproved. Evidence can be either testimony or exhibits. Testimony is what you hear from people who take the witness stand and swear to tell the truth. However, the questions the lawyers ask the witness are not evidence. Exhibits are documents, photographs, and other physical items that are admitted during trial. I will admit evidence according to the rules of evidence. The lawyers are advocates for their clients, and they have a duty to represent their clients to the best of their ability. They must follow the rules of law, trial procedure, and evidence during the trial. They may make motions or objections if they believe that any rule is not being followed. What the lawyers say in making or responding to objections is not evidence. If the lawyers make objections and I overrule it, that means that the evidence is admitted and you may consider it. If I sustain an objection, this means the evidence is excluded from the trial and you may not consider it. You should consider only the testimony and only those exhibits that are admitted. You should not assume or infer anything about the evidence which I have excluded. If you happen to hear or see evidence that I end up excluding from the trial, you must disregard it entirely in your deliberations and in arriving at your verdict. None of my decisions and nothing I say during the trial are evidence. Sometimes I may need to deal with the lawyer's motions or objections without you being here in the courtroom, so I will excuse you to the jury room. We'll try to limit such interruptions, and we ask you to please be patient when they do happen. This is the part where I always tell you guys you're going to be mad at us through most of this trial. We're going to have a lot of conferences where we need to send you out. We're going to tell you it's going to be about 10 minutes and then it's going to be 20. So please understand that we're doing our best and we're being as efficient as possible, but know that you are going to be removed more often than you like. And that's just part of trial, okay? The trial will proceed as follows. First, the attorneys may give what are called opening statements. Opening statements are not evidence. The state goes first because they have the burden of proof. Second, the evidence will be presented. Third, the attorneys may give closing arguments. They may also point out evidence they believe supports their position. What the lawyers say in closing arguments is not evidence. Fourth, I will explain to you the specific law that applies to this case. I will then ask you to go to the jury room to deliberate and reach your verdict. It's important that you pay close attention during this trial. If you cannot hear or see any evidence, or if you are suffering from any discomfort that distracts you, please inform me or the deputy, and we will do what is needed to make sure that you can hear and see the evidence and give it your undivided attention. If you need a break at any time, please raise your hand, alert the deputy, or simply just catch my eye. You must decide this case based only on the evidence admitted during the trial and the law that I will explain to you. You may not conduct any research on your own about this case or about any people or places mentioned during the trial. You may not visit places mentioned in the evidence. You may not use any outside sources such as dictionaries, Google, social media, ChatGPT to get information about this case. You may not use any outside sources to research legal terms or the law. Finally, you may not read or listen to any accounts of this trial that may appear on your computer, your phone, in print, or on the radio. So anything that's in the media while you're in this trial, you need to disregard and avoid. You may not discuss this case with anyone, including family and friends, or let anyone discuss the case with you or around you. This includes discussing or sharing information on social media. You must not discuss this case, even amongst yourselves, until the actual deliberations begin. That is, after you have heard all the evidence, arguments, and the law that applies to this case. You have pens and notepads. Please keep in mind, you may take notes. If you take notes, please do not let your note-taking distract you from paying attention. You may not share or discuss your notes with anyone until you start deliberating at the end of the case. And notes are not evidence, they're only memory aids. They are not more important than your own impression or memory of what the evidence may have been. While you may consider another juror's notes to refresh your memory, you should rely on your own memory of the proceedings. Don't be influenced by the notes of other jurors unless their notes help you in determining your own independent memory. You must leave your notes in the jury room, except when you're in the courtroom. My staff will destroy your notes at the end of deliberations. You'll get a transcript. You will not. This is important because it's not television. You will not get a transcript of witnesses' testimony, so you must remember in a way that works best for you what they said on the witness stand. This concludes my preliminary instructions, and we're now ready for the lawyers to give their opening statements. So let's have a sound check right now. Who had any trouble hearing me just now? All right, and you know what to do if you do, because it's critical that you guys hear. So if you can't hear the lawyers or you can't hear the witness, it's okay to interrupt and let us know that. All right. Is the state going to make an opening statement?
Yes, Your Honor.
Okay. That goes for the screen too. If you can't see the screen, let us know.
one thing that you're going to see throughout this trial is that the technology in Fulton County is not stellar, it's not the best, and it's not the most high-tech equipment. So at times you're going to experience, along with us, lags, and in this instance, PowerPoint is we click from slide to slide, lags as we play videos. So we just ask you to remain patient. I know a lot of you guys either in IT or have spouses, family members, and friends who are in IT, so you're used to the fastest and the best. You're in the wrong place for that. So I'll apologize on behalf of all the parties in advance. 8 bullet holes. 8 holes, defects from bullets in the vehicle that Secoriea Turner was seated in the back seat laying on her phone. 8 bullets fired into the Jeep that Mr. Omar Ivy was driving, that her mom, Charmaine Turner, was seated in the front passenger seat. And little 8-year-old Secoriea Turner seated in the back seat, doing what 8-year-olds do, playing on a cell phone, looking at TikTok. No one knew that on July 4th of 2020, as this vehicle that Secoriea was playing, had a great day celebrating the 4th of July, would be the last day that she'd be alive. No one knew that this would be the last moments that Secoriea Turner would get to play on TikTok, would get to make a TikTok, would be the last moments that her mother, Charmaine Turner, would hear her laugh. When they woke up that morning, they had no idea that these would be the last moments that she'd ever spend with her 8-year-old. And why? Because the conscious, intentional, and deliberate actions of this defendant on July 4th of 2020, when he consciously and intentionally pointed his rifle, AR-style firearm, at the Jeep as it traveled around what you'll learn and hear about throughout this trial, a makeshift barricade blocked off by large orange blocks and orange cones that we see on the roads for construction. When the Jeep that Secoriea Turner did not submit to the authority of this defendant and his gang members, he intentionally pointed and pulled the trigger of this AR-15 style rifle, firing into the vehicle that Secoriea was just trying to get home. Get home to continue to celebrate the 4th of July, that fellowship with her family like we all do on the 4th of July, celebrating America and fireworks and fun. But that all ended because of the acts of this defendant. One bullet that traveled through the back of this Jeep, traveled through the trunk, traveled through the seat, and traveled into the back of 8-year-old Secoriea Turner, killing her on July 4th, 2020. Having 8 short years of life with her family, with her friends, her hopes and dreams of being a student at Spelman ended in those few moments. Now, what you're going to learn through the course of this trial, and the evidence is going to show, is that little Secoriea, she loved to dance, she loved to play on TikTok, she loved to make TikToks, she was happy, she was full of life, she was full of joy. She loved to read, she loved to learn. And because she loved to read and learn, she had already decided that she wanted to be a student at Spelman and would talk to her mom all the time about how excited, even though she was 8, that she was going to college at Spelman here in Atlanta. She loved her family. And all of that came to an end because of the senseless gun violence, the senseless, deliberate actions of this defendant when he fired his rifle into the vehicle that Secoriea was traveling in. Now, I want to talk to you, and we covered some of this yesterday and the day before on Monday, about the summer of 2020 and what was going on not only throughout the country, but specifically here in Atlanta. It was a time that most of us had never experienced. It was an unprecedented time. It was a time where we were going through a global pandemic. We were experiencing surges during the summer of COVID-19. In conjunction with that, we were experiencing civil unrest because of protests that were supporting, rightfully so, racial injustice, trying to fight for change. But during the summer of 2020, as we moved into July 4th, at 1238 Pryor Road, near the Wendy's, Rayshard Brooks was shot and killed. And as a result of him being killed, that Wendy's the next day, on June 13th, was burned out. As many of you had heard, we talked about it yesterday and the day before, about what we remembered, what we read, the information we had processed as it relates to what happened to Mr. Brooks. And as a result of the shooting and the death of Mr. Brooks, there were protests throughout the city of Atlanta. There were protests specifically at the Wendy's where he was killed. And as we all are aware, that Wendy's was burned out. And that Wendy's, that area of 1238 Pryor Road, the intersection of University and Pryor, became a hub or a place where protests would happen often, where people would come, gather, and support each other. But that changed as time moved on, and as time continued. It became more focused on things of violence, things that led to the death of little Secoriea Turner. And what you're going to see and what you're going to learn throughout this trial, you'll be tired of seeing maps and hearing us talk about locations. But this is the general location we asked you about yesterday. We talked about how you're familiar with it, how often you've been driven by it, and things of that nature. And this is the package store, which will be central to the facts and the evidence, as well as the BP, the area where the Wendy's was, and further down where you can see that there are warehouses on University Avenue. Now, as we move through the trial and as the evidence and the testimony unfolds, you're going to hear about, on July 4th, the conditions and the description of what 1238 Pryor Road intersection with University looked like, what the conditions were, the people who were out there. You're going to hear about the fact that the police had coined the term or called this an autonomous zone, where during this time, the defendant and members of his gang had taken advantage of the fact that there was minimal police presence due to the unrest as it relates to police brutality and things of that nature. And what you're going to learn, what we talked about, is that they set up a barricade, a checkpoint, an armed checkpoint in this community and your community, making it to where they controlled everything. They controlled the authority of who could come and go and pass based on the blockades and the barricades that they had set up. They were armed with firearms to control and to assert their authority. And what you'll see, and as you will find out, when you don't submit to that authority, there's consequences. And Secoriea Turner paid those consequences because Omar Ivory, a member of this community, had the audacity, in their eyes, to not submit to their authority, to not allow them to control his egress and ingress. He went around the barricades, and as a result, they shot into his car. You're going to see video surveillance. You're going to see a lot of photographs. These are examples of what the barricades look like. The large orange blocks, the construction cones that we see, unfortunately, all around the courthouses. We all travel the next couple of days here and back. Now, you're going to hear from a lot of witnesses who are going to be able to describe the conditions of July 4th, 2020. Members of this community, employees and people who work in the area. You're going to hear from Gerald Kembor, who is a individual, a male who's been a MARTA bus driver at this time. He worked with MARTA and was very familiar with the city and drove many routes throughout the city. On July 4th of 2020, his route included the University and Pryor Road area and stops. He's going to talk about the barricades that he experienced, the having to ask permission to move throughout the city in that area, that he saw individuals armed with rifles that he was forced to stop. And the only way he could ever get through is if he asked permission, and he was granted that permission. You're also going to hear from members of that community, Chris and Samantha McCord. And you're going to hear about their experience on July 4th of 2020, when they attempted just to go home, just like Secoriea and her family, just to get across the barriers right over the second blockade where their home was. And they were denied access. Chris and Samantha McCord are going to talk about the fear that they felt, the anger that they felt, that they couldn't go to their home and their community that they had invested in, that they loved, that these people were preventing them from enjoying what they helped build and create. You're going to hear from Mr. McCord and Mrs. McCord to tell you that the firearms that the individuals, to include the defendant, pointed at their heads and at their vehicle as they told them they weren't allowed to pass through. How they told Mr. McCord he was acting disrespectful, and how they made Mr. McCord turn around. What you're going to learn is shortly after the McCords were not granted access is when Secoriea and her family were driving in the area. What Charmaine and Mr. Omar are going to tell you is that they had spent the day with family. They had spent the day having fun, 4th of July, at Miss Turner's mother's house, that the family had gathered. They barbecued. They had shot off fireworks. They did what most people do on the 4th of July. And that they were coming home roughly a little after 9:30, and they got off at Pryor Road, University Avenue, exit off I-75. And they got up there, their home was not far from it, and they needed to stop at the local package store, the All-American package store. And as they drove up to the intersection, Mr. Ivory will tell you that in looking at it, he believed it was closed. He saw that some of the windows were dark and boarded up. So he didn't stop there, is what Ms. Turner and Mr. Ivory will tell you. And what they'll tell you is they were going to go home. That their house was on the other side of the barricades, and they hadn't encountered the barricades before. They saw them, and Mr. Ivory will tell you that as he approached the area where the barricades were, he went around, he didn't stop, he went around the first barricade, and as soon as he did that, there was gunfire at his feet. They'll tell you the fear that they felt. They will tell you the moments in which the gunfire is entering their vehicle, going past their heads and their bodies, and how they survived by the grace of God. And what they'll both tell you, and what Charmaine will tell you, is in the moments as the gunfire is occurring, she hears her daughter cry out, "Mama, Mama, I've been shot." She hears her 8-year-old little girl sitting in the back seat on their way home scream her name for the very last time. Because of the deliberate actions of this defendant, because someone had the audacity not to stop at this unlawful barricade, at this unlawful checkpoint. What both Ms. Turner and Mr. Ivory will tell you is they made it past the second barricade. They pulled over shortly down the road to attend to Secoriea. Ms. Turner will tell you that she dove into the back seat. She will tell you that she did everything in her power to keep her daughter alive, to try to stop the bleeding, to do whatever she could do to provide any medical assistance to keep the little 8-year-old with her. What both Mr. Ivory and Ms. Turner will tell you is they attempted to call 911. At that time, 911 was experiencing a high volume of calls. And Mr. Ivory will tell you that he called and called and couldn't get through. He will tell you that as he was making the decision to stay where he was and continue to call 911 or to go to the nearest hospital. And what he'll tell you is he kept calling 911 and he eventually got through, but his instincts, his gut told him he couldn't wait. So while he's on the phone with 911, and you'll hear he's talking and walking them through the fact that they're driving to the hospital, and he's taking little Secoriea to the Atlanta Medical Center. He's doing everything in his power as her mother attempts to try to stop the bleeding, trying to keep Secoriea awake. Now, the evidence will show, and you'll hear from officers and detectives, that Mr. Omar did arrive at Atlanta Medical Center. When he arrived, he was followed by an officer who was close in the area, who saw Mr. Ivory kind of speeding through the city, down Boulevard, and into Atlanta Medical Center. And you'll see and hear from this officer, you'll see his body cam, of the urgency in which they arrived, and you'll see the moment that Secoriea is taken from the back seat. She's rushed into the emergency room. And what the evidence will show, the testimony will be, is that they tried everything medically possible to save this little girl. They tried everything. But nothing they did could stop, could fix what this defendant did to this little girl. You will hear Charmaine and Mr. Ivory about the moments when they find out that Secoriea didn't make it. That she was never going home. That they were going to be leaving the Atlanta Medical Center without their 8-year-old little girl. And Ms. Turner will tell you how awful that moment was. How it changed her life and her family's life forever. How nothing has ever been the same since Secoria's death. You will hear from additional officers who responded to the Atlanta Medical Center because of the call of little Secoriea arriving with a gunshot wound to the back. You will hear from checks from the homicide unit, how the investigation began, how Sergeant Epps was the first officer with the City of Atlanta Police Department to arrive right behind Mr. Ivory, Ms. Turner, and little Secoriea, and how he notified homicide, and how the investigation began, unfolded, and moved from the scene of where Secoriea died to the scene of where she was shot. With Wendy's at 1238 Prior Street. And what the evidence and testimony will show, and what will be admitted into evidence, as I said, 911 call, both from Mr. Ivory as well as from Mr. McCords and his wife. You will hear about statements witnesses made on the scene, and they'll testify in court about it. You will hear about the defendant's distinctive clothing, a very important piece of evidence as to how the detectives with the City of Atlanta Homicide Unit are able to track and identify this defendant. You will hear about the defendant's actions after the shooting. And you will hear about statements this defendant made with his counsel during a press conference shortly after Secoriea was murdered. Now, the timeline of events will be set up by the 911 call. That's where the chronology starts, relates to the investigation, and Detective Julian Shepard, who was assigned as the lead detective in the homicide unit. And he will tell you he was able to locate the call at approximately at 9:45 p.m. from Mr. McCord, referencing how he'd been held at gunpoint, how guns had been pointed at him and his wife's head at their vehicle. You will hear about the 911 call through Detective Shepard that he was able to locate that Omar made. And like I said, you hear about the hardest decision Mr. Ivory had to make in determining whether he should remain, continue to try to get a hold of 911, or attempt to get the quickest medical care by driving Secoriea to the City of Atlanta, to the Atlanta Medical Center. You will also hear, again, from Sergeant Epps, who will talk about how he saw the Jeep speeding, how he could tell based on the way that the car was driving and his training experience that this car was trying to get medical help as fast as possible. And Detective Shepard will talk about the first steps that he took after being assigned the lead detective in this case, how he attempted to canvass the scene and talk to witnesses, how the crime scene was photographed and processed, and evidence was collected. He will tell you, along with several crime scene vets that responded, about the area, and when they arrived, they had to move quickly through the scene because it wasn't safe. There were still members of the community, there were still members of the violent protests that night with guns on scene. So, as they are focusing on processing the scene, they're also focused on their safety and making sure that they can do their job in the safest way possible for everybody still remaining out there. And Detective Shepard's going to tell you about the difficulty he had in canvassing and speaking to witnesses, the unwillingness of people to provide information, and how that affected his investigation, and how he had to move through his investigation in different ways and look for evidence in ways that he typically had not done in the past. He will tell you about his interview with Ms. Charmaine Turner that we talked about. He will tell you about his interview with Mr. Ivory. He will talk to you about his interactions with Mr. McCord and his experience that night on July 4th. He will also talk to you about the members of his team in the City of Atlanta Homicide Unit and how they assisted, and how members of Homeland Security, specifically you'll hear from Investigator T, how he assisted in the process, how he utilized all different units throughout the City of Atlanta Police Department in order to get justice for little 8-year-old Secoriea Turner. He started because of the resistance that he was receiving that night as it relates to witnesses speaking, as to finding people willing to make statements. He did a Be on the Lookout, a flyer that was distributed through the media, through news outlets, on social media, asking for anyone to come forward to assist in any information as it relates to the death of Secoriea Turner. He will tell you that he continued to receive information. He will tell you he continued to canvass the area for any video surveillance that could have captured anything that happened during the moments of Secoria's death. And what he'll tell you is that an assisting investigator with Homeland Security, Investigator Jason T, was able to recover and extract several hours of footage from the surrounding businesses through just doing knock and talks, asking for help as it relates to the owners of the All-American Package Store, the owners of the BP gas station, and a warehouse that was just past the area of the second half of the barricade, just past the area where Omar Ivory had pulled off to the side as everyone tried to save Secoriea. And what you will see and what you will hear about is the angles and the footage that was able to be recovered. And I know we're all used to CSI and all the other different crime scene shows that are on TV with our 4K and clear as ever video surveillance, rings that seem to capture, ring cameras that seem to capture everything, even if there isn't movement, even though they're supposed to be motion activated. But you will learn, ladies and gentlemen, that's TV. That the camera footage that we were able to locate as it relates to the moments before, during, and after Secoria's death is not 4K. It doesn't capture every angle on the scene. It doesn't capture outside of certain areas where the cameras don't reach. What you're going to notice is that the cameras are not as clear as it shows on Criminal Minds, capturing every angle and aspect of someone's face, clothing, and things of that nature. What Detective Shepard will tell you is that after Detective T was able to locate the video surveillance from the 3 businesses, he then watched hours of footage, having to piece and connect the footage together so he could get a full 360, 180 view of certain angles so he could get justice for Secoriea. This is the view he was able to get from the BP gas station. And just on the left of the screen, is just outside of this camera, would be the warehouse where he was able to pull video surveillance and pointed in the direction of the BP. That's what we're seeing here. So what Detective Shepard will talk to you about in his review and hours of review footage is he was able to locate the time in which the McCords pulled into the liquor store parking lot after they had experienced being held at gunpoint. after they had been told they couldn't come through, after they were made to turn around. And you'll see on the video surveillance, the McCords get out, looking confused, scared, wondering what happened, why they weren't able to move through. And you'll see the defendant in his distinctive clothing, his jeans with faded out areas on his thighs and down towards his shin. You'll see that he's in a distinctive red shirt with white writing. You will learn through witnesses that the writing on the back of the shirt talks about Piru Bloods, Elm Street. And you will learn the significance as it relates to that and this defendant being a member and associate of the Piru Bloods gang. Detective Shepard will tell you that in his review of the footage, he was able to locate two persons of interest at the beginning of the investigation that he identified. The defendant being the individual in the red, and then in the white t-shirt and the black jeans, the co-defendant, Mr. Jerry McKinney. And what I'll say as it relates to Mr. McKinney is that we're here for the trial of Mr. Connley. Mr. McKinney is not on trial before this jury at this time. Your focus as it relates to the guilt and innocence is on Mr. Connley. Mr. McKinney is not attached or a part of this trial that is before each and every one of you during the next couple of days. And what Detective Shepard will tell you is that he continued to review footage. And as he reviewed footage, he saw shortly before the shooting a MARTA bus. And through his number of years with the City of Atlanta Police Department, he knew that MARTA buses typically had cameras. And for once, he knew that this was an agency, this was a transportation industry that had great cameras, that had camera footage that we would hope to see on TV. Camera footage that reveals details of your face, of your clothing. So he reached out to members of the MARTA Police Department and MARTA Transportation, and he was able to identify that bus that was on the route from University and Pryor. He was able to identify the driver. He was able to get the camera footage. And from his review and receiving of the camera footage, he was able to get the photographs of Mr. McKinney. He was able to use the video footage to take screenshots of the details of Mr. McKinney, of Mr. Connley, his red shirt, his rifle, his black bag that he had over his body. He then put that in a bolo, or Crime Stoppers Tips flyer, in which he again released throughout the city, through the media, through canvassing, going from person to person, house to house, asking if they recognized the person in the flyer. And as he did that, he did the same as it relates to Mr. McKinney, as he was able to get clear footage or clear pictures to distribute as it relates to him as a person of interest for the murder of Secoriea Turner. What you will learn and what you will hear and see is that as a result of these flyers, as a result of the media blast of the Volo related to this defendant, Julian Conley, he came forward on July 13th of 2020. When I say he came forward in a press conference that he had arranged with his counsel at the time in front of several news outlets, one being in front of Tom Jones with WSB-TV, and other media outlets, Fox 5 with Angelique Proctor, where they all met in a central location, a central area, and he made statements while on or during the press conference that his counsel made statements on his behalf as it relates to his picture being distributed as a person of interest. How he admitted that the person in the red shirt with the white writing, with the AR-style rifle hanging from his body, and that black bag was him. That picture was of him. That he was on the scene at the time Secoriea Turner was killed. You will see distinct differences just a few days later in Mr. Connley's appearance. You'll see that he's changed his appearance. He's cut his hair. It's nothing like the photos that you see, that you saw previously, where he had a longer hair in twists that were coming down. And like I said, he made statements as it relates to identifying himself in the video that had been distributed by the City of Atlanta Police Department. And what Detective Shepard will tell you, again, the distinct difference in his appearance on July 4th and July 13th during the press conference. And as Detective Shepard saw, like all of us, we happened to be watching the news, watched it live, learned information, and took that information and added it to his investigation. Added it to the hours and hours of video footage that he had watched. Because he now can identify the individual that he saw shooting at the vehicle in the red shirt with the white writing and the large rifle as Mr. Ivory passed through and around the barricade. And what Detective Shepard will tell you is that a day and a half later, from the conference the defendant held, he took out arrest warrants. And what Detective Shepard will tell you is that a common practice is once arrest warrants are taken out, they're turned over to the Fugitive Task Force team for assistance in locating and apprehending a suspect in which warrants have been sworn out for. And what Detective Shepard will also tell you is that as that was done, as the Fugitive Task Force began to do their part of the investigation in locating the defendant, the defendant's attorney, Jackie Patterson, who now goes by the fly lawyer Patterson, as you will hear. During that time, he reached out and arranged for Julian Conley to turn himself in. And then on July 15th of 2020, the defendant was taken into custody and placed under arrest. Now, you are also going to hear from experts that will be utilized during the state case in chief. You'll hear from the chief medical examiner, Dr. Karen Sullivan, and she will talk to you about the autopsy that she did on 8-year-old Secoriea Turner. She'll talk about the cause of death, which was the gunshot wound that she received in her back. She'll talk about the manner of death, how she classified it as a homicide. She will describe to you, and you will hear about a rifle projectile that was removed from Secorea's little body. And she'll talk to you, and you will see photographs of the hole and how large it is. And she'll tell you that's typical, not unusual, an individual shot with a high-powered rifle round, like Secoriea was. You will hear, toward the end of this trial, from Sarah Van Holm with the Georgia Bureau of Investigations. Ms. Van Holm will talk to you about her expertise and what she's been doing at the GBI for a number of years. That she's a firearms examiner, and that she has examined, analyzed, and made determinations about hundreds of different projectiles and ballistics evidence that she has compared. She will tell you that she received a number of ballistics evidence collected from the crime scene where Secoriea was shot. She will tell you she received that projectile that was removed from Secorea's body. And what Ms. Van Holm will tell you is that in her comparison of 7 shell casings, cartridge casings, as Ms. Van Holm will call them, in her comparison of those shell casings, she will be able to tell you that all of them came from one gun and that they were all fired from an AR-15 rifle. She will also tell you that the single bullet that was removed from Secorea's body is consistent with being fired from an AR-15 style firearm. Same caliber of ammunition, 5.56, 45, as the 7 shell casings that were collected from the scene. You will also hear from another member of the GBI back in 2020, Jared Coleman. You will hear about his qualifications. You will hear about his experience and his training in gangs throughout the country, throughout the state of Georgia, and the number of years that he has worked and documented different gang members, identified different signs, and things of that nature. And he will tell you about how he's able to make his determination about the gang evidence that he reviewed, about how the gang element is connected to and part of the cause of Secorea's murder. He will tell you about what we talked about here today, that members of the Piru Bloods gang seized control of the intersection of University and Pryor. He will tell you that that seizure of that intersection was to dominance, gain a position of dominance of that territory, of that area where Mr. Brooks was killed, and his connection, God bless you, to the Piru Bloods, and how that this seizure was done via the armed checkpoint. And he will talk about the importance of a refusal to submit, a refusal to recognize the authority of these gang members, and how that refusal is met with violence, and here specifically gun violence. Now, as the judge mentioned earlier, again, this isn't like TV. The technology, as you've seen throughout this presentation, is poor. What I want you to keep in mind is that we're giving you pens and paper, old school style, where you can take notes. I would encourage you to take notes, because though Madam Court Reporter is constantly typing and having to take down all the things that we say that don't make sense, the things that she can't understand, we can't give you a transcript of that as you go back to deliberate. Your transcript will be your notes. Your memory will depend on each and every one of your collective taking of notes. So I encourage you to take notes and to pay attention during the testimony and evidence, because everything that's presented to you is important. Everything that is presented to you is to get justice for 8-year-old Secoriea Turner. And what I want you to remember is that 8-year-old Secoriea, her family, the McCords, Mr. Camber, other witnesses who will testify throughout this trial, they're not on trial. He is. He's on trial for his actions on July 4th of 2020. And what the evidence will show, ladies and gentlemen, that there was no excuse, there's no mitigation, and there's absolutely no justification for what this defendant and the members of his gang did to little 8-year-old Secoriea on July 4th, 2020. Their actions show nothing more than the fact that they have no regard at all for human life, no regard for a precious little 8-year-old Secoriea Turner who was just trying to get home. The only thing that the evidence will show as it relates to this defendant and what he wanted and what he was concerned about was escaping the responsibility for his actions, to not being held accountable for the things that he, ladies and gentlemen, is responsible for from July 4th of 2020. And that's your job, ladies and gentlemen. Your job is to listen to the testimony and the evidence. And at the end of this trial, hold this defendant accountable. Hold him responsible for the things he did on July 4th of 2020. For cutting Secoria's life short, or only allowing her to live a very short 80 years, making her hopes and dreams of Spelman a reality that will never come true, making it so Ms. Turner will never hear her daughter laugh, see her dance, do the things that she loves. And the evidence will be clear during the course of this trial that this defendant acted intentionally, he acted deliberately, and he consciously made the decision to point, shoot, and pull that trigger at the vehicle that Secoriea was just trying to get home. The evidence will be clear. And at the end of this trial, ladies and gentlemen, myself, my co-counsel, Ms. Young, will have the opportunity to address you again, have the opportunity to talk to you about the injustice that little 8-year-old Secoriea Turner had to endure at the hands of this defendant. And we will have the absolute privilege to stand before you and ask that you return the only verdict that speaks the truth, and that this defendant is guilty of each and every charge in this indictment that you heard about during the beginning of one year. We ask that you hold Julian Conley accountable for his deliberate acts that caused the death of Secoriea Turner, and find him guilty on all counts. Thank you.
Do you all need this stretch before you hear the other side's argument? Fine. Okay. All right, who will be making the opening statement for the defense?
I will, Your Honor.
Okay, thank you. Go right ahead, Mr. Ragas.
9 days. The investigation into that precious girl's life lasted 9 days. On July 4th of 2020, her precious life was taken. And on July 13th, Officer Shepard said he was sure he had his person. He said he was 99.99% sure. 9 days later. And when you rush to justice by rushing to Julian, you inevitably land somewhere far different. And when you rush to justice by rushing to Julian, sometimes you just find yourself sitting in a seat charged with a crime you did not commit. And make no mistake about it, the evidence will prove that he did not commit this crime. And we're going to prove it. The math, the mother, and the man behind the wheel all agree, or at least they did, that Julian didn't do it. The math, the mother, and the man behind the wheel, they all said it, or at least they did, that he did not do it. We're going to start with the math. The state is saying that Julian pulled the trigger that killed that precious girl. They're going to say that she sat in the back seat in the middle of that car as it drove through the barricade. They're going to say that Julian was standing by the driver's side door as the car drove by. They're going to say that he fired into that car. And you are going to see video, and they are going to point to a person they are going to say was Julian. Well, what the math will say is that if Julian is the person they say he is, he didn't cause that girl's death. She was, and there'll be no dispute about this, a beautiful, beautiful 8-year-old girl. And that did not deserve to happen to her. But more than one thing can be true at the same time. What happened to her as she sat in that car seat should not have happened. And what is happening to him as he sits in that seat should not be happening. What the math will tell you is that if that person is him, he could not have caused that girl's death. Because if he is firing, as the evidence will show, and they'll have a medical examiner to testify about the fact, if he's standing and firing at the driver's side door, their medical examiner is going to tell you that the bullet entered that beautiful young girl from right to left, from low to high, from back to front. What that medical examiner will tell you is that the person who fired that shot, that trajectory is consistent with a person being on the right side of the car or near the back right side of the car to create a low to high, back to front, right to left trajectory. The evidence is going to show that a person standing by the driver's side door could not create that. But beyond the math, On that night, as they rushed to the hospital, and that beautiful girl's mother was in that hospital, and she was talking to officers. She told those officers, "Help me, help me, help me." They said, "How can we help you?" She said, "I saw the person who killed my baby. He was wearing black mask, black vest, dressed like y'all, all black with a long gun." Later, as she was in the hospital, she told officers again, "I saw the person who killed my girl. He was wearing black mask, black vest, dressed like y'all, carrying a long gun." You are going to see pictures of a person wearing all black, carrying a long gun, kneeling and firing upward. You are going to see that picture. We rush to justice by rushing to Julian. Sometimes you don't bother looking at the evidence along the path. Because, as the evidence will show, the mother, and even the man behind the wheel say they didn't do it, or at least they did. In addition, they talked to that young woman the next day, the next couple of days at her home, and she repeated it. She repeated it. She repeated it. "I saw the man, black, dressed like y'all, bounty hunter, black vest, long gun." That's what she said the night of. She said the day after. She said the day after. And so did the man behind the wheel. They talked to him. And he said, "I saw the people who fired into that car. They were wearing black. They were dressed like bounty hunters. And they had long guns." That is what he told them. That is what he told them. But not only did he tell them that, he gave Officer Shepard pictures. He gave Officer Shepard a picture of people in some crew. And he said, "These are the two people." He talked about one guy being darker with a beard and another guy being short with dreadlocks. Those are the two people who shot into that car. Dressed in black, dressed like bounty hunters. He said the same thing that young woman said. But when you rush to justice, now rushing to Julian, you ignore. You ignore evidence along the way. July of 2020, that was a different time. People were home. That was in the height of COVID. And as the state indicated, that was what the police called an autonomous zone. And what the evidence will show, that will be a very generous description, for they just gave it up and said, "Y'all good over there." They provided no protection. They provided no security, they provided no peace. They allowed that area to police itself. They call it an autonomous zone, but again, that's very generous. They abandoned their responsibility. They abandoned their duty. It was July 4th. It was Independence Day, as the state said. But the evidence will show it was more than Independence Day. The evidence will show it was almost Independence Month. They were independent of law enforcement. They were on their own, not by choice, but because they were left no choice. That came at a time you had George Floyd in Minnesota, and witnesses will talk about this. You had George Floyd in Minnesota. You had Ahmaud Arbery down in Brunswick. And you had Rayshard Brooks right there at Wendy's in June. And when that happened, when all those things happened, people congregated at the scene of the Rayshard Brooks shooting. They congregated at that Wendy's for one night, for 1 week, for 2 weeks, for 3 weeks. They stayed, many of them stayed overnight. And in that autonomous zone, as they call it, it wasn't about gangs taking over, and the witnesses will tell you it had zero to do with gangs. In fact, as it was Independence Month, what you had in that community was, in their eyes at least, and they'll tell you, the community felt like it was winning. And not just winning, it was winning finally. They saw George Floyd. They saw Ahmaud Arbery. They saw Rayshard Brooks. And in that area, they had tents. They had grills. The community was feeding itself. You even had people who planted a garden. They were trying to provide haircuts for kids. They even had a porta potty they had there by the Wendy's because it was Independence Day, but it was Independence Month. Not by choice, but because they were left no choice. And as they took care of themselves and stayed there and tried to, as they'll say, have their voices heard for once, be seen, be seen. They started hearing the rumblings, they started hearing the rumors of outsiders coming in, of the Klan coming in, various other things, the rumors that they'll tell you they heard. They're not going to show you any evidence of any defendant bringing in a barricade. The barricade was left by the city because it was Independence Day, but it was Independence Month because law enforcement said, nah, y'all good over there. So they brought barricades. And as the witnesses will tell you, under the influence of all of what was happening in June of 2020 of the George Floyd and the Ahmaud Arbery and the Rayshard Brooks, also they were cognizant, they knew of, they were aware of, and they were frightened about Heather Heyer, a woman protesting in West Virginia, Charlottesville, Virginia, where a car rammed the protesters. Because on this scene, on this night, as it had been the case for previous month almost, you had kids playing in the street. You had people cooking out, kids doing cartwheels, and families cooking and sharing food. This area is about 50 yards. It's less than a football field, 50 to 100 yards from beginning to end of that barricade. And that was the area. You'll see the video. Because it was Independence Day. That was the area where they wanted to keep their piece of America safe. The witnesses will tell you it was not about harming anybody. It was about healing everybody and protecting the community. So what you'll see is, you'll see that car go barreling past that barricade. You'll see that car hit somebody as it tries to jump out of the way. And you'll see somebody who's hit raise up and start firing. And you'll see that car keep going. And then you'll see somebody at that second barricade kneel in fire. All they wanted to do was keep that area safe. Because when that car came by, nobody at that barricade knew who was in it. They didn't know that that beautiful young girl was sitting in the back seat. All they knew, and they'll tell you, was that car come barreling past. And they knew there were kids in the street and people in the street in the community. They had to keep safe because it was Independence Day. As the evidence will show, 9 days into what should have been a thorough investigation, Officer Shepard said that he was 99.99% sure that Julian Conley fired those shots into that car. But you will see, as you've heard, that Julian Conley had on what they have called, and what the evidence will show, and what the picture will show, a distinctive red shirt. Julian Conley had on a distinctive red shirt. But when you rush to justice by rushing to Julian, you ignore the fact, as the evidence will show, that the mother, and the man behind the wheel all said something different. Because what the mother said was all black, dressed like a cop. What the man behind the wheel said was all black, dressed like a bounty hunter. What the man behind the wheel showed pictures of were people in all black, dressed like a bounty hunter. But he had on distinctive red. But what happened? The evidence will show that they got his picture. They got his picture when he went to that MARTA bus. Didn't threaten anybody, but they got his picture right there on the camera provided by the MARTA bus. In his red distinctive shirt, not black. And the evidence will show they put that picture on TV. And the evidence will show that when they put that picture on the TV, that man said, I want to go clear my name. And he called a lawyer. I am not responsible for him calling himself the fly lawyer, but he called a lawyer. He wasn't the fly lawyer. He called a lawyer who was a friend of his mom. He called a lawyer that he knew was in law enforcement with his mom when they worked at Clark University Police. So that was the person they called, Jackie Patterson. Jackie, can you help my son? And that man, to clear his name, I'm wearing red because at this point the evidence will show flyers had already gone out. Black, dressed like a bounty hunter, but he saw his picture on the screen and said, let me go turn myself in. Let me clear my name. And when he did that, he rushed to justice by rushing to Julian. He disregarded a lot of facts along the way. He turned himself in, thinking he would clear his name. When Officer Shepard made that statement 9 days later about being 99.99% sure, that was before he'd even requested to view the results of the autopsy. Because, again, when you rush to justice, you don't have to wait for details. Before he got the results, before he'd seen the results of the medical examiner, he already made up his mind. I'm so happy you're here. At some point, the state is going to tell you that you get to use your common sense and don't check it at the door. I'm so glad you're here. Because the common sense will tell you that when you are 99.9% sure, what you're looking for after that. So when he made that statement about being 99.9% sure and saying that Julian was standing by that driver's side door firing into the car, he didn't know at that point that the bullet entered from right to left, low to high, back to front. They get to the hospital that night. It's about 10 o'clock or so, Atlanta Medical Center. And while that mother is in the hospital with their daughter, the man behind the wheel is outside in the parking lot. And he's telling them from outside in that parking lot, I'm going to have a lawyer tomorrow. His exact words were something along the lines of, I'm going to have a top flight lawyer tomorrow, zero money down. We're talking hours from the time that beautiful girl was shot. So glad you're here. So glad you're here. Because although, as the evidence will show, that I guess they call him Detective Shepard, concluded his investigation in 9 days, it's not over. It is not over. Because he doesn't get the last word. He doesn't get to say that you're 99.9% sure. You will get to examine all the evidence. You get to hear all of the witnesses. you get to do something they didn't do. When you rush to justice by rushing to Julian, you ignore the fact that the mother, and the man behind the wheel all agree that he didn't do it. You get to finish the investigation. You'll get to find him not guilty of all those charges, and I thank you for your attention.
Thanks, everyone. Do you need a break before we start with our first witness? You need a restroom break? Okay, go ahead and step out.
All rise for the jury.
Can I see the attorneys at the bench for just a sec?